Welcome to the First District Court of Appeals. We have only one case that is going to be argued today, and that is State of Ohio versus Daniels. If you'll notice, Judge Kinsley is not here today. She will be participating in the decision of this case. She's going to watch the argument, but she was unable to be here in person for the argument, so she'll watch the video of it. So we have, for the appellant, we have Ms. Lape, and for the appellee, Mr. Wessels.
Correct.
Good morning. Ms. Lape, would you like to reserve some rebuttal time?
2 minutes, please.
Okay, I will keep your time. I will use the lights on the podium. When you have 1 minute left of your initial time, the yellow light will come on, and then red means that you're finished.
Thank you.
All right, whenever you're ready.
Good morning. May it please the court, Mr. Wessels, Stephanie Lape on behalf of the appellant, Mr. Daniels. Mr. Daniels is requesting reversal on his one assignment of error that the trial court erred in overruling his motion to suppress. This case really comes down to whether or not the police had probable cause to initiate this traffic stop. There's kind of two issues here, the improper change of course and the window tint. I'm going to start with the improper change of course.
Does the window tint matter if, I mean, that would only be if we find that the improper change of course didn't amount to probable cause?
I think they both, I mean, if you were to say the improper change of course didn't happen, that wasn't enough probable cause, then they could have stopped for the window tint.
Right.
So I think both.
Okay.
Yeah. So as far as the improper change of course goes, at the time that, this kind of comes down to, is there enough competent, credible evidence in the record to say that this traffic violation occurred? And we don't really know what the trial court's findings of facts are on this specific issue. The trial court just simply says there were multiple traffic violations, so there's probable cause to stop. All of the evidence created at the time of the stop. Fortunately, we have body camera in this case, we have MVR, and we have the 527. That's all created at the time of the stop. And at the time of the stop, all the evidence says we're stopping this guy because he didn't turn his turn signal on when he made this turn into the laundromat.
Well, hold on a second. I thought they testified that they stopped him because he changed lanes without using a turn signal, not the laundromat turn.
That was the testimony at the suppression hearing 8 months later from Officer Cox. However, at the time of the stop on the body cam, Officer Pure, I may not be saying that correctly, who wasn't at the suppression hearing, during the stop on the body cam, he says, Mr. Daniels, I'm stopping you because you didn't turn your turn signal on when you made that turn into the laundromat.
Okay.
And then on the MVR, we see it rolls back 30 seconds, we see he did turn his turn signal on. And so now 8 months later at the suppression hearing, Officer Cox is saying, well, no, I stopped him because he didn't turn his turn signal on going into the parking lot. This is completely new evidence to anyone that's reviewed the case and the evidence that's created at the time of the stop.
So you went into the well, I don't know if it was you, but whoever the trial lawyer was, went into the suppression hearing thinking that the reason for the stop was the failure to use the turn signal, and then they had the video that showed that he did use a turn signal.
Correct.
Okay.
Correct.
But what do we do with the fact that the judge found the officer to be credible?
The judge did say the officer was credible. However, he doesn't tell us, I'm finding him credible, and here's what I'm saying is the probable cause for this stop. He's not saying, I think he didn't turn his turn signal on when he changed lanes, or addressing whether it was the turn. The judge doesn't address at the trial court level why he's finding probable cause. He just says there's multiple traffic violations here. And then we have these two conflicting things. One is testimony 8 months after the fact, and officers forget what happens frequently. It is 8 months later. But then we have the evidence that was created at the time of the stop that says, we're stopping this guy because he didn't turn his turn signal on. In the MVR, Officer Cox testifies about that, explains that it rolls back 30 seconds. When they turn their lights on, it rolls back and catches the 30 seconds prior. And that's sort of the point of that. We get to see what the traffic violation was, why they flipped their lights on. Of course, not everything is always caught on camera, but here that turn signal was caught on camera.
But they were I'm a little confused because I thought they had already decided to pull him over before he used his turn signal to turn into the lot.
That seems to be the testimony at the suppression hearing.
But isn't that why it was caught on camera, because their lights were on at that point? Or, I mean, I'm just a little bit confused, because was he turning into the lot because he was getting pulled over?
I don't believe so.
Okay.
I don't believe that's what the record says. Officer Cox testifies that we were already going to pull him over, but then we saw him turn in this lot, so we went ahead and initiated the stop.
Oh, they were going to pull him over for the window tint?
According to Officer Cox, it's because of the change of.
Okay, the prior lane that's not on the video. Okay, got you.
So I'm going to move on to the window tint. Again, we don't have a specific finding from the trial court saying the window tint was too dark, so there's probable cause. We just know the trial court is saying there was multiple traffic violations here. And really, the only two that we're talking about possibly is the change of course in the window tint.
Your client wasn't cited for the window tint violation, was he?
He was
I
not.
didn't think he was, okay.
He was cited for an improper change of course, but that could be either scenario, the turn or the changing of lanes.
That would be the same citation?
It's the same code, same citation, and the citation doesn't specify why he's being cited, but the 527, which is separate, says it's the turn, not the change of lanes. I got a little off track there. As far as the window tint is concerned, there was no citation. The window tint was never mentioned. The only evidence that we have in the record about the window tint is a brief mention by Officer Cox. That's what piqued his interest. There's never any other mention of that. There's no testimony about, here's why I know as an experienced officer that window tint was dark. And we don't really get to see the window tint up close in the MVR until he's already stopped. They've already decided to stop him. We know at about 30 seconds is when you can see close enough to the car, and up until then, we know that they've already turned their lights on. They've already decided to stop him once we can see the window tint and whether or not it's dark. If you look at the MVR in that first 30 seconds, they're really far away from him, and you can't really tell at that point if the window tint is dark. At the same time, there's nothing in the record to tell us how this officer knew that the window, there's just no testimony about it, just this brief mention. There are cases in this court where this court's found that's enough to stop someone, Mackey and Sims. However, in those cases, officers testified, I knew that the window tint was dark for this reason, because I couldn't see in the windows, I couldn't see facial features. We don't have any testimony like that at all, nor do we have them measuring the window tint. We don't have a citation for the window tint. Like the state points out, and I agree, for purposes of probable cause to stop, there doesn't necessarily have to be a formal citation. The tint doesn't have to be measured. The officers don't have to give enough testimony to prove the guy would have been found guilty of the violation. But this brief mention just isn't enough for us to find probable cause. There's not enough in the record to say the window tint was enough to stop Mr. Daniels. If we're going to say officers can just get up there and say that window tint was dark, it piqued my interest, and give no other testimony about it, no other testimony about why the window tint was dark, what did you observe that tells us that the window tint was dark, then we can just stop anybody and say it was the window tint. The record is very bare on this. It's our position this was nothing more than a pretextual stop, and the officers are attempting to justify it after the fact. And that's all I have. Is there any other questions?
Just to be clear, though, with regard to the lane change, you are basically asking this court to determine that the officer's testimony was not credible.
Yes.
Okay. Thank you.
Is that all? Thank you.
Thank you. May it please the court, opposing counsel. I think maybe it would be helpful to clarify the record, and I think what I'm saying will be borne out by what the officer testified to at the scene when it comes to whether or not this improper lane change happened, because I do think the determination depends on whether or not there was this improper lane change. The officer who testified, which is Officer Cox, not the one who was driving or who filed the 527, which was Officer Epure, the officer who was there at the hearing and who testified, explained how the rollback of the MVR recording system works. Essentially, what his testimony says is they witnessed this improper lane change. They pulled behind the defendant in this case, and they were beginning to run his plates, which is standard procedure for what they do. They also say at that time that, or Officer Cox testified that the window tint at this point piqued the suspicion of both him and Officer Epure. While they were running the plates, he began to initiate a left-hand turn into this laundromat. And the officers testified, at least Officer Cox testified, that because he was already turning in and because they had already witnessed this improper lane change, they decided to turn on the sirens at that point. And because they turned on the sirens, it begins to roll back at 30 seconds. So I think that once he began to turn into the laundromat, that's when the sirens were actually initiated, and that's when it starts the 30-second rollback. So when it comes to the evidence that this improper lane change happened, it's pretty much confined to the testimony of Officer Cox and whether or not the court believed that to be credible.
You're saying that Officer Cox is the officer who saw the improper lane change?
I believe Officer Cox testified that both he and Officer Epure noticed the improper lane change.
But who told the defendant that the reason why he was pulled over was because he didn't use the signal when he turned into the parking lot?
I'd have to go through the entirety of the body-worn camera. I believe Officer Epure mentions both the, I don't remember the exact language, but I do believe Officer Epure is the one who mentions a turn into the laundromat as well as the window tint, which I was going to get to later.
And what about the 527? Does that say that the reason for the stop was because of the turn into the laundromat?
I have to look at the particular language. It does say, I believe, if I have it here. Officer stopped, arrested for heavy window tint and not using a turn signal the proper distance from the turn. That is what was written in the 527 by Officer Epure, who again did not testify at the hearing. Officer Cox is the one who testified and is the one who wrote the ticket. But also Officer Cox testified that the improper lane change was the reason that they ended up getting behind the defendant's vehicle. And you can actually see that in the MVR recording. You can see them change from the right lane to the left lane in accordance with Epure's testimony and begin to speed up to get behind the vehicle. Which is consistent with what he said. We witnessed the improper lane change. We pulled behind the vehicle. We began to run the plates, and then the vehicle initiated the left-hand turn. And Cox does say that they witnessed, and you can see on the MVR that he did turn on his signal before he turned into the laundromat. But I don't believe, at least consistent with what Cox testified to, that turn signal into the laundromat was the reason for the stop. He was pretty clear throughout the course of the motion to suppress that the reason they began to initiate the stop was because of the improper lane change without the use of a signal.
And the reason why they got behind him.
Correct.
And you can see that on the video.
Consistent with what Officer Cox testified to, oftentimes when they are about to initiate a traffic stop, they'll want to run the plate and run the record to make sure they have enough information about the person who's in the vehicle should they choose to pull them over. So I believe, at least consistent with the evidence that Cox testified to and that is in the MVR, I believe their intention was to pull over the vehicle. It just so happened that that vehicle decided to pull into a parking lot before they could go through and actually finish running the plate. That's what Cox testified to. So I do think that in terms of when this boils down to just the officer testimony as to whether or not the trial court found that to be credible, and the trial court did say it found it to be very credible, that was the trial court's word. I believe that's a determination for the trier of fact, and that is to say the trial court believed that the officer had probable cause, reasonable suspicion that this improper lane change happened, and I do think because of that reason that the stop was proper. With regards to the window tint, I disagree that the record is threadbare on this issue. Cox testified to it at the motion to suppress hearings. He said both that it piqued his suspicion and it was one of the reasons for the stop. Officer Epier explained to the defendant at the time that his window tint was heavy, and that's one of the reasons he was stopped. And this kind of, I think, counts against opposing counsel's argument. It was put in the 527 that he was stopped for a heavy window tint. So at the same breath, opposing counsel wants you to trust that the turn signal that was included in the 527 was accurate, but discount the reference to the heavy window tint in the 527. Ultimately, though, you can review the body-worn camera and the MVR, and it's my submission that the window tint does appear heavy on the back of the vehicle and on the side of the vehicle. To the extent that Officer Cox testified that the window tint piqued his suspicion, that would be consistent with a heavy back or side window tint. It was something that was argued by the state. I would agree with counsel that the judge doesn't say which traffic citations. The judge simply says multiple traffic citations. I can only assume that the state argued, and the state with the one with the burden says that the traffic citations were both the improper change of lanes and the window tint.
You mean
because they were-
violations?
Yes, correct.
He was not cited for the tint.
Correct. He was not cited for the
Okay.
tint.
So the only traffic violations presented by the state was the improper change of lane and the tint.
That's my
And the
understanding.
judge held multiple.
The court said, taking into the circumstances, the stop was reasonable and cites. He said the officer testified there were multiple traffic violations. That testimony was very credible. I find that multiple traffic violations is enough to make the traffic stop reasonable. Obviously, I mean, if the court saw some other traffic violation that I'm not aware of, but I believe the only ones that the state argued at the time were the improper lane change and the window tint. And so if there are multiple, I don't know what other ones he'd be
Let me
referring
ask you, I thought there was some testimony, and I may be wrong, but that the defendant in this case was driving under suspension. Is that correct? I don't think he was cited for that. At least there wasn't anything in the transcript, but I thought there was something in a brief or somewhere that he was driving under suspension as well.
I believe they had run his plates, and I don't recall specifically if there was, but I don't think it wouldn't have factored into. That was, I think the officer testified to that was not the reason for the stop. That goes to, the officer testified that, again, they got behind, they began to run the plate. They might have at some point determined after fully successfully running those plates that there was some type of suspension, but I think it was conceded by the state that that didn't play into the reason for the stop, which was the thing that was challenged in the motion to suppress. I have nothing else, unless there's any questions. Thank you.
Thank you. Ms. Late?
Just briefly, I probably won't use up my whole 2 minutes.
You actually have a little more than that because you didn't use your initial.
The officers say we're running his plates, but if you look at the NVR, they're really far away. They're not running his plates yet. They can't be running his plates. They can't be seeing. Maybe they're trying to get to his plates. I don't know, but this all happens really quick. He turns into that thing, and then they're stopping him. He does the turn, and then they're stopping him. They immediately say, Mr. Daniels, we've stopped you because you didn't turn on your turn signal when you made that turn. And I agree, the 527 does mention window tint. However, again, it's still a mention. It's still, there's dark window tint. That's not enough. We have a motion to suppress hearing. We're challenging that this stop. Well, I wasn't there, but, you know, Mr. Daniels, represented by counsel, is challenging that there's probable cause to stop him, and it's the state's burden to prove that there was a traffic violation, and the state put on no evidence to show that this window tint was a valid reason to stop. We're just saying window tint. We're not telling you anything about it. We're not giving you any further information about that. And it was the state's burden here. It was Officer Epier that says in the body cam, not Officer Cox. Officer Epier was not at the suppression hearing, but his body cam was played at the suppression hearing. And it was him that told Mr. Daniels. He was the driver of the vehicles, the cruiser as well. It was the turn. We stopped you for the turn. That's in the body cam. And it is the state's burden here. The state could have brought him in and clarified that, but we don't. That's not in the record for us. It's the state's burden to show why there was probable cause here. The only thing that we have about this improper change of lane is Officer Cox's testimony 8 months after the actual stop. It's never mentioned anywhere else, not in the citation, not in the 527, not in the body cams, not in the motor vehicle camera. And unless there's any questions, that's all I have.
I guess, I mean, how do you reconcile the fact that we do at least have video of the officers getting behind your client, which kind of demonstrates that they're starting to follow him on this 2-lane highway? I mean, doesn't that kind of add some credibility to the testimony that they did that because they saw a traffic violation?
Or because they thought he was suspicious for some other reason. It's our argument this is a pretextual stop, which my version of, an example of that would be, they see this guy, they think he's suspicious for some other reason. They know him or whatever the case. This is the type of car they think drug dealers drive. Whatever the reason, they get behind him to follow him, to wait for him to make a traffic violation, and then they can stop him. That's all I have.
Okay, thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. Have a good rest of your day.